Unless your contract has a specific COVID-related stipulation or something that allows you to delay the closing in case something comes up that's COVID-related, you don't have an escape from the agreement of purchase and sale. A lot of people have suggested that there might be an act of God or force majeure. That won't be the case when it comes to a real estate contract. Whatever's in your agreement, that's what it is. That's the end of it, nothing else. In the event that you can't complete the transaction in accordance with the agreement of purchase and sale, you'll be found in breach of contract. In the event that the unexpected occurs, contact your attorney as soon as possible and make reasonable efforts to advise the other party and try to come up to a mutually amenable solution for all parties. In the event you can't complete the transaction, there's at least 3 things what you and your lawyer should attempt to do. 1, maybe to seek a mutual release from the transaction. The other party's circumstances may have also changed. It may be okay for all parties, if everybody's on the same page, to release one another from the transaction and put that transaction to an end. Now, if a mutual release isn't a viable option because there's a domino effect that's occurring, you will want to talk to your lawyer, and you may, instead of signing a mutual release or any sort of form of settlement that would absolve any rights or obligations under the contract, you may want to have a direction signed by all parties whereby the proceeds sitting with the listing brokerage's trust account would be released to the party that's harmed so that they could immediately proceed to mitigate loss. Now, more often than not, people are going to want the mutual release signed so that there's no liability that extends after the settlement and the disbursement of the funds, but you have to carefully consider all of the options that may be on the table so that you can minimize the amount of damages in the long term. You have to seek legal advice. If ultimately the parties can't reconcile, they can't settle, there's no direction to release the funds, the only other option at this point to have the funds released from the trust account is for one of the parties to obtain a court order to have that money released. This will usually coincide with a lawsuit to that effect, whereby the party that has been harmed will be also seeking damages and or other remedies that may be available to them. Now, the amount that they seek in damages or the remedy that they seek has to be reasonable and has to be substantiated. I can't just walk into a court and say, because the other party didn't close my transaction, I need $5 million in damages. Those losses must be substantiated and further mitigated before a court will award anything. Because all damages need to be substantiated, if I am a party that has suffered loss because of the other party's inability to close due to financing or whatever reason they might have, before I can sue, I need to come up with my damages. Usually, mitigation will involve the seller relisting the property insofar as possible, and then trying to obtain as much for that property that they can. And if there's any sort of a loss due to that relisting relative to the final sale price, usually the seller will be able to sue for the difference in the original purchase price and the new final sale price after making reasonable efforts to obtain as much as they can on the market. Now, if you're the breaching party, you want to be very reasonable. You want to try to negotiate with the other side, potentially seek a mutual release, but be as reasonable as possible. One thing that's very important to appreciate is that you don't leave any cards on the table. If you put together a reasonable proposal that the other party outright rejects, you may be able to use that as a shield in case they sue you after the fact. What I mean by this is that if you try to make reasonable efforts to delay the closing or act in a way that is deemed reasonable at a later state, and the other party failed to accept your negotiations and instead went with another offer whereby they lost a bunch of money, if you can prove in court that they wouldn't have lost as much money if they would have went with your proposal, there's a good chance that you could end up using that as a shield in the long run. So be reasonable in your attempts to mitigate. Speak to your lawyer, speak with your real estate professional, and see if there's any outside of the box solution that you can come up with. There may be assignment opportunities, there may be opportunities to obtain third-party financing that isn't from a major financial institution. If your down payment's high enough, you really want to make sure that you haven't left any stone unturned. I hope this video helped. Ricky Rathore here again from Remax Metropolis, real estate lawyer at Rathore Baig Professional Corporation. We'll see you again next time. Bye for now.